Hello and welcome back to this course on community rights and forest governance. As we learned previously in this module, during colonial rule and even after independence, the government expanded its control over extensive tracts of forest land by declaring them as reserved and protected forests. Partly because of their improper recording, this process extinguished the traditional rights of forest dwelling communities and eroded community rights. As a result, forest dwelling communities came to be perceived as illegal occupants or encroachers of government forests. The Forest Rights Act of 2006 recognized a set of these forest rights and vested them in the scheduled tribes and other traditional forest dwellers who have been residing in forests for generations, but whose rights were not recorded. These include the various rights of individuals and communities and the special rights of primitive tribal groups, nomadic communities, and pastoralists. This was a transformative law.
The important thing to remember is when we look at the Forest Rights Act and its preamble, there is a paragraph in the preamble that talks about the historical injustice which has taken place against the Adivasis and the forest dwelling communities of the country. And it clearly states that this historical injustice has resulted from the fact that under the colonial government, there was a failure to recognize the pre-existing rights of forest dwellers, and this failure also continued into independent India, and that Parliament is now taking a stand to undo this historical injustice. Now, when we're talking about historical injustice against the Adivasis, it's very important to recognize exactly what we're talking about and what is the exact context within which the Parliament enacted this law. So, it's a little bit important to go back into the 19th century. 1865 is the first forest legislation that was enacted by the British government. Now, the British government was very clear why it's enacting this law, as well as a number of other legislations that happened around the same time with regard to land, water, and so on. The clear purpose was to establish the colonial government's control over forest lands and to use the forest resources, primarily timber, for the industrial machine. The industrial revolution which was happening in England, and also for industrial processes that were being put into place in India itself for the colonial regime. Now, the forest machinery, which is the administrative machinery, was also set up approximately around the same time. There was this very interesting sort of innovation, you can say, in the law, where the colonial government declared that there are certain areas which are going to be known as government forests. And if people have pre-existing rights, that in the legislation itself it was recognized that people do have pre-existing rights. There are communities who have usufruct rights, cultivation rights inside those forests. But it was left to the communities to figure out how they're going to establish those rights, in opposition to the colonial government's declaration that these forests are now government forests. Subsequently, in the amendments that took place, new legislations came in, but they followed the same pattern. In fact, became more and more consolidated the colonial control over forests in a much more intensive way, leading up to the 1927 Indian Forest Act, which continues to be in force today.
Firstly, the Act recognized some rights in forest land. Forest land under this law means land of any description falling within any forest area and includes unclassified forests, undemarcated forests, existing or deemed forests, protected forests, reserve forests, sanctuaries, and national parks. Forest dwelling scheduled tribes and other forest dwelling communities have the right, as individuals and as communities, to occupy forest land for habitation or for self cultivation for livelihood. People who have received pattas, leases, or grants over forest land issued by any local authority or any state government have rights to convert them to titles over that forest land. They have the right to protect, regenerate, conserve, and manage any community forest resource. They also have the right to the settlement and conversion of all forest villages, old habitation, unsurveyed villages, and other villages in forests, whether recorded, notified, or not, into revenue villages. A revenue village is a small unit of administration. Forest dwellers who were illegally evicted or displaced from forest land without being rehabilitated, as they were entitled to prior to December 13, 2005, have rights to rehabilitation and to alternate land. Forest dwelling communities who can establish that they were displaced from their dwelling and cultivation without compensation for the development interventions of the state, and where the land has not been used for the purpose for which it was acquired within 5 years of that acquisition, also have rights to land. Forest dwelling people also have the right not to be evicted from the land they were occupying if the process of recognition of rights in relation to that land is not complete. Primitive and pre-agricultural communities have community tenures of habitat and habitation. All individual rights, that is, those rights that did not belong to the community as a whole, would be registered in the case of married couples jointly in the name of the husband and the wife. Forest dwelling scheduled tribes means the members or community of the scheduled tribes under the Constitution of India who primarily reside in and who depend on the forests or forest lands for bona fide livelihood needs. This includes the pastoralist communities among the scheduled tribes. Other traditional forest dweller means any community or member of a community who has for at least the last 3 generations prior to December 13, 2005, primarily resided in forest lands and depended on the forest or forest lands for their bona fide livelihood needs. 1 generation means 25 years.
Next important feature is community forest rights. In tribal areas, we have both tribals and non-tribals. The Act recognizes, records, and vests Nistar rights to communities and individuals. For example, the collection of minor forest produce, harvesting fishes, collecting firewood and medicinal herbs, etc. All these rights were from time to time restricted by the Forest Department before enactment of this Act. The Forest Department at times used to limit a community's access to forests, at times restrict the collection of firewood or mahua, and some false cases were also pressed against communities. All these actions were restricted after the Forest Rights Act because it recognized communities' Nistar rights. The Act specifically says that these Nistar rights existed since generations and that we are now recognizing them. The right is not limited to the collection, but also to sell the remaining after their own use. Transit permits have also been granted to Gram Sabhas.
So, secondly, the law recognizes community rights, including Nistar rights, which are the traditional rights to use forest produce, rights of ownership over minor forest produce that has been traditionally collected within or outside village boundaries, and the rights of access to collect, use, and dispose of such produce. Rights to use the products of water bodies, such as fish, grazing rights, the rights of traditional seasonal resource access of nomadic or pastoralist communities, the rights to protect and conserve community forest resources, and the rights to traditional knowledge and intellectual property related to biodiversity and cultural diversity. Minor forest produce includes all non-timber forest produce of plant origin, including bamboo, brushwood, stumps, cane, tusar, cocoons, honey, wax, lac, tendu or kendu leaves, medicinal plants and herbs, roots, tubers, and the like. With the community rights of ownership over such produce, the monopoly rights of forest departments in their trade in many states have become illegal. Rights holders have the rights, either as individuals or as cooperatives or federations, to undertake individual or collective processing, value addition, and marketing of minor forest produce, and any fees or other charges placed on these activities are also illegal. Community forest resources include customary forest land within the traditional or customary boundaries of the village, or the seasonal use of landscape in the case of pastoralist communities. This land may therefore be part of reserve forests, and protected areas such as sanctuaries and national parks to which a community had traditional access.
The special feature of this Act is the word recognition, which means that the law recognizes the historical injustice meted out to the tribals of this country because we never recognized their rights over forest and resources. The law, hence, wants to undo this historical injustice by recognizing and recording their rights over forests and resources that they were traditionally using and conserving. There are some important features of this law. First is that this law is aimed at the democratization of forest governance, which then leads into the recording and transfer of forest management rights and authorities to Gram Sabha. So, it is a very important law.
Apart from recognition and vesting of all these rights to forest dwelling individuals and communities, the Forest Rights Act also set up democratic procedures for decision making at the level of settlements, with the Gram Sabha playing a central role. The Gram Sabha's powers of governance have now become a feature across several laws, and we will learn about them now, starting with the Forest Rights Act. Development facilities managed by the government, such as schools, hospitals, Anganwadis, and electricity and telecommunication lines, for which less than 1 hectare of forest land or less than 75 trees for each hectare need to be felled, can only be cleared with the recommendation of the Gram Sabha. Secondly, people and communities with forest rights and the Gram Sabha have the powers and duties to 1. Protect wildlife, forests and biodiversity. 2. Ensure that catchment areas, water sources and other ecologically sensitive areas near their land are adequately protected. 3. Ensure that the habitat of forest-dwelling scheduled tribes and other traditional forest dwellers is protected from any form of destructive practices affecting their cultural and natural heritage. And 4. Ensure that decisions taken in the Gram Sabha to regulate access to community forest resources and stop any activity which adversely affects wild animals, forests, and biodiversity are complied with. To exercise these powers, the Gram Sabhas can constitute committees for the protection of wildlife, forest, and biodiversity from amongst its members. These committees have to prepare a conservation and management plan for community forest resources, which it then must integrate with the working plans and micro plans of the Forest Department, with any modifications that the committee considers necessary.
If we look at the provisions of this law, the first aspect is that of community forest resource rights, which is the soul of this law, according to which Gram Sabha is responsible for conserving, protecting, and regenerating the forest resources within the traditional village boundary. This means that the law gives management rights to Gram Sabhas. Second is Section 5 of the Act, which says that the Gram Sabha and committees constituted under Section 4(1)(e) are empowered to protect forest resources, forest area, biodiversity, wildlife, and culture. It vests the responsibility to protect the forests, its resources, and wildlife to the Gram Sabha. This law reduces the control of the Forest Department that had been established over the past 60 to 70 years and hands it over to the communities.
It is important to appreciate here how the right to participate in the governance of forests is essential for the enjoyment of the right to forest resources. The latter may not often be possible without the former.
Community rights and community resource rights can be understood this way. Suppose a village is granted community rights to collect mahua, but mahua can be collected only if the tree exists. The right to conserve the trees is granted under community resource rights. Without the consent of the Gram Sabha, even the forest department cannot cut the mahua trees. The Ministry of Tribal Affairs issued an order in this context, according to which forest departments, which used to operate as per its working plan, will have to integrate the management plan made by Gram Sabhas after the recognition of community forest resource rights with their working plan. This means that the forest department's management alone will not work, but they will have to manage forests with communities. The state government will provide funds to Gram Sabha or its Section 4(1)(e) committees for this whole process of forest management.
The Gram Sabhas also have powers in relation to the resettlement of forest dwellers from spaces known in the law as critical wildlife habitats. These are areas that, in the opinion of the central government formed on the basis of scientific and objective criteria, need to be kept inviolate for the purpose of wildlife conservation. Previously, we had learnt about them in the context of the protected area model of wildlife conservation. Where a state government wants to declare an area within a national park or a wildlife sanctuary as a critical wildlife habitat, it can initiate a process to modify the rights of forest dwellers in that area. This process may affect their rights, may even involve their resettlement from the area. The resettlement, however, can only commence after the rights of forest dwellers in that area have been recorded following the process in the Forest Rights Act. Another point we must note is that no resettlement of forest dwellers can happen until the Gram Sabhas of the area have consented to a resettlement package prepared by the government that secures the livelihood of the affected forest dwellers. This applies to resettlement for any purpose, whether it is part of a project that has a non-forest purpose or if it is for a forest purpose such as the creation of some inviolate space for wildlife conservation. So far, we have seen the powers of the Gram Sabha to govern forest land under the Forest Rights Act. Let us now turn our attention to the powers of the Gram Sabha under some of the other laws that we have already learned about, starting with the Wildlife Protection Act. In 2006, around the same time that the Forest Rights Act was passed, the Wildlife Protection Act was amended to provide for laws that could support the implementation of Project Tiger, a plan to protect the endangered species of big cats. These amendments set up the National Tiger Conservation Authority, which would guide conservation efforts, including through the management of areas declared as tiger reserves. Tiger reserves are the core or critical tiger habitat areas of national parks and sanctuaries that are required on the basis of scientific and objective criteria to be kept inviolate for the purposes of tiger conservation without affecting the rights of the scheduled tribes or such other forest dwellers. This meant that these were areas where, in the opinion of the state government, human activity could not coexist with the tiger population. The reasoning behind the creation of such areas is that tigers are territorial big cats, and the scientific consensus seems to be that some such area without human activity is required to sustain a viable population of tigers. The management of tiger reserves had to be in accordance with a tiger conservation plan prepared by the state governments. Among other things, this plan was required under these amendments to ensure the agricultural, livelihood, developmental, and other interests of the people living in tiger-bearing forests or a tiger reserve. The burden of providing for these needs would fall on the buffer or peripheral areas of tiger reserves. The limits of those areas had to be determined on the basis of scientific and objective criteria in consultation with the Gram Sabhas involved. Before an area is declared as a critical tiger reserve, the state government is required to take the following steps. 1. Complete the process of recognition of rights and acquisition of land or forest rights of the scheduled tribes and other forest dwelling people. 2. Establish with the consent of the scheduled tribes and other forest dwellers, and after consulting ecological and social scientists familiar with the area, that the activities of those people are sufficient to cause irreversible damage and threaten the existence of tigers and their habitat. 3. Obtain the consent of the scheduled tribes and other forest dwellers and come to a conclusion that no coexistence options are available. 4. Prepare a resettlement package that provides for the livelihood of affected individuals while fulfilling the requirements of the National Rehabilitation and Resettlement Policy. 5. Obtain the informed consent of Gram Sabhas and affected persons for resettlement. And 6. Provide the facilities and allocate the land for the resettlement area. Coming back to the Forest Rights Act, it also sets out the evidence required for recognizing and vesting these rights over forests and resources, and a framework for recording them. You can learn about this process in greater detail in the reading materials accompanying this module. But understand now that here again, the Gram Sabha is the primary authority for the determination of these rights. The Gram Sabha has to initiate the process of determining rights by receiving claims, consolidate and verify them, prepare a map delineating the area of each claim that it has verified, and finally pass a resolution that it recommends these claims. These powers and duties of the Gram Sabha are exercised on its behalf by a Forest Rights Committee that is elected from among its members. The rules made under the Forest Rights Act provide more detailed guidance on how the Forest Rights Committee must be constituted, how the Gram Sabha must call for and acknowledge claims, the manner in which forest dwellers and communities can make those claims, and the evidence that can be shown in support of them, how the Forest Rights Committee must verify claims, and the process for recognizing claims. The claims recommended by a Gram Sabha are scrutinized at a subdivisional level committee and then at a district level committee that finally approves the claims. Having noted the space for the participation of local communities in the governance of forests under the PESA and under the Forest Rights Act, let us now remind ourselves of what we learnt about that aspect under the Forest Conservation Act.
The Forest Conservation Act itself is a very, what shall we say, an ambiguous term. It was passed with the intent of slowing down the pace at which state governments were handing out forests for non-forestry purposes, primarily for agriculture, but also for developmental projects, mining, dams, and so on and so forth. As you can see, in the post-90s period particularly, the interest in development continues and increases. So in a sense, the handing out of forests for developmental purposes has not really been prevented or slowed down by the Forest Conservation Act. It's the handing out of forests for agricultural purposes which has been slowed down by the Forest Conservation Act.
The Forest Conservation Act and the rules made under it set out a procedure for securing the approval of the state and central governments for any project that requires the use of forest land for a non-forest purpose. Approval is given in 3 stages. The in-principle approval of the state government, followed by the in-principle approval of the central government, followed finally by the final approval for the project. Before in-principle approval is given by the state governments, the district collector must ensure that the process of recognition and vesting of rights under the Forest Rights Act has been completed in that area, and then obtain the permission of the Gram Sabha that has jurisdiction over the forest area in question for the proposal and any measures to ameliorate or compensate for the damage that would be caused to the forest. So just like the Forest Rights Act requires that no resettlement of people from forest areas happens without a process of recognition and settlement of forest rights and the consent of the Gram Sabha to the resettlement package, the rules made under the Forest Conservation Act also place a similar procedural requirement for the grant of in-principle approval by state governments for the diversion of forest land for a non-forest purpose. That provides another space in the law for communities living in and around forests to participate in the governance of those forests.
Large tracts of forest land are being diverted for development purposes. The Act specifically mentions that in such circumstances, no one will be evicted from forest land until their rights have been recognized. Most often, people were evicted saying that they did not have any rights, but this Act clearly says that no one can be evicted till the rights recognition process is complete. So, this Act also functions as a huge safeguard.
Now, previously in this module, we also noted how the National Forest Policy of 1988 and the policy of joint forest management had also provided some space for such participation. Let us note some details of those approaches now. The key element in JFM is that communities have the power to manage the use of forest by members and also exclude non-members. The benefits to them are direct access and control on the use and sale of most NTFPs, that is non-timber forest produce, and a share in the income from timber as well as other intangible benefits from local ecosystem services like water recharge, pollination, wildlife habitat, etc. A contract between the JFM committee and the forest department stipulates how benefits from the JFM area are shared between the two entities. While local communities get all the income from non-timber forest produce, their share of income from the sale of timber is much lower and has been a contentious issue. A circular from the Ministry of Environment and Forests in 1990 and guidelines issued in 2000 and in 2002 provided the framework for state-level rules on JFM. A JFM cell was established in the Ministry of Environment and Forests in 1998. Forest Development Agencies, or FDAs, were developed at the district level as an autonomous federation of JFM committees, and State Forest Development Agencies, an umbrella organization of all FDAs in a state based on guidelines issued by the Government of India. By 2010, more than 24 million hectares, that is, about 30% of the country's forest area, was covered by JFM programs. That said, we need to remind ourselves once again that the entire structure of JFM is built on top of a forest policy and not on any law made by the legislature or the executive. This means that communities do not have any rights under law to participate in joint forest management. The last set of provisions that we will learn to understand the participation of local communities in forest governance is the Biodiversity Act. We learned previously in this module how the National Biodiversity Authority, which is the regulatory body for India's biological resources and knowledge relating to those resources, has the duty to ensure the equitable sharing of the benefits arising from research into and commercial exploitation of biological resources. So, when it considers an application from any person or organization that is ordinarily restricted from accessing those biological resources to access those resources, or an application for the grant of intellectual property rights based on information or knowledge about these resources, or an application for the transfer of the results of any research into these resources, it has to ensure that its approval is only granted subject to conditions that require the equitable sharing of the benefits arising from the use of these biological resources and their byproducts, innovations, and practices associated with their use, and applications and knowledge relating to them. These conditions must also be in accordance with the terms and conditions that are mutually agreed between the person applying for such approval, the local bodies concerned, and the benefit claimers. So, who exactly are benefit claimers under this law? Benefit claimers are the conservers of biological resources, their byproducts, creators and holders of knowledge and information relating to the use of such biological resources, innovations and practices associated with such use and application. So, for example, if a forest dwelling community has historically conserved a particular species of herb and has information relating to its medicinal use, then they are benefit claimers in relation to that herb. We should note here that the community is not required to put forward any formal claim to be considered a benefit claimer. Their traditional role as conserver of that herb and holder of knowledge about its utility is sufficient. Some of the forms of benefit sharing that the National Biodiversity Authority can make a condition for any of these activities are the grant of joint ownership of intellectual property rights to itself, the grant of joint ownership rights to benefit claimants where such benefit claimants are identified, the transfer of technology, the location of production, research, and development units in such areas which will facilitate better living standards to the benefit claimers, and the payment of monetary compensation and other non monetary benefits to the benefit claimers as the National Biodiversity Authority may deem fit. Communities can have their voice heard in the decisions of the National Biodiversity Authority and the state biodiversity boards through biodiversity management committees that have to be constituted by all local bodies in India. These biodiversity management committees promote conservation, sustainable use, and the documentation of biological diversity, including the preservation of habitats and the conservation of plant varieties bred for cultivation, including by ancient farmers. Each of them have to prepare a people's biodiversity register in consultation with local people containing comprehensive information on the availability and knowledge of local biological resources, their medicinal or any other use, or any other traditional knowledge associated with them. While taking any decision relating to the use of biological resources or knowledge associated with such resources occurring within the territorial jurisdiction of a biodiversity management committee, the National Biodiversity Authority and the state biodiversity boards must consult that committee. The committees also have the power to levy charges on any person for accessing and collecting any biological resource for commercial purposes from areas within its jurisdiction. Fees collected in this manner will go into the local biodiversity fund, which will also contain, among other funds, any grants made to it by the state governments and the National Biodiversity Authority. The state government has to use these funds for the conservation and promotion of biodiversity in the areas falling within the jurisdiction of the concerned local body and for the benefit of the community, as long as the use is consistent with the conservation of biodiversity. With that, we have learnt the various spaces provided in the law for forest dwelling people and communities to participate in the governance of forests. That also brings us to the end of this module on the laws that govern the use of forests. We first understood the laws that gave governments control over forests and govern their power to determine the use of forests. Then, we learned about the negotiations by communities dwelling in and around forests all over the country to participate in the governance of the forests that they had historically lived on and benefited from. Finally, we learned about the spaces present in the law for communities to influence the governance of forests. With this understanding of the law, you can move ahead to learning about how communities can use the law to influence and participate in the governance of forests, and also protect their interests. This requires both a more practical understanding of these laws and procedures, but also some skills and attitudes that you will need to use them effectively. That is what you will learn in the last module of this course. Thank you for watching.